connecting options to what you already know. In the first part of this chapter, you learned how a standard contract for sale is created and how its provisions control the path from offer to closing. You saw that a typical purchase contract is bilateral. Both buyer and seller promise to perform and can be held to those promises once there is offer, acceptance, consideration, capacity, and lawful purpose. In this section, you extend that knowledge into a special type of agreement that is common in both residential and commercial practice, the option to buy contract. An option to buy is still a contract, but it behaves differently from the purchase contracts you are used to. Instead of immediately binding both parties to complete a sale, an option reserves the buyer's opportunity to buy in the future while holding the seller's promise firm in the present. Understanding how options work, when they are appropriate, and how to draft them clearly is an important skill for any real estate professional, especially in creative financing, investment, and commercial transactions. What is an option to buy? An option to buy is an enforceable contract in which a potential seller, called the optionor, grants a potential buyer, called the optionee, the right to purchase a specific property at a stated price and on stated terms within a defined time period. In exchange for this right, the optionee pays the option or valuable consideration that is separate from the eventual purchase price. The key feature is that the optionee is not obligated to buy. The optionor, however, is obligated to sell if the optionee chooses to exercise the option. Until the option expires or is exercised, the seller is effectively locked in, while the buyer controls the decision. For this reason, an option is a unilateral contract while it is still just an option. Once the option is exercised, it becomes a bilateral purchase contract where both parties must perform. Consider a simple example. A buyer wants to purchase a home for $150,000, but needs 2 or 3 months to sell a boat to raise the down payment. The seller is willing to wait, but does not want to risk losing other buyers for nothing. The parties agree that the seller will grant the buyer an option to buy the home for the agreed price anytime within 90 days in exchange for $1,000 of non-refundable option money. If the buyer exercises the option, the $1,000 will be credited toward the earnest money and down payment. If the buyer does not exercise, the seller keeps the money and is free to sell to someone else when the option expires. This example illustrates the essential trade-off in an option. The optionee pays for control and flexibility. The option or gives up the freedom to sell to others, but receives compensation for that limitation. How options are used in real estate practice. Options can appear in many different forms and situations. A tenant may negotiate a lease with an option to buy, allowing time to test the property, build credit, or accumulate a down payment while renting. In that case, the landlord might agree to credit a portion of each month's rent toward the future purchase price if the tenant exercises the option by a certain date. The renter gets a pathway to ownership. The landlord gets a committed tenant and a higher likelihood of eventual sale. Options are also common in commercial and development transactions. A developer may need time to investigate zoning, traffic, utilities, environmental impacts, and permitting before being willing to purchase a parcel. Rather than risk losing the site to another purchaser, the developer can negotiate an option that freezes the price and preserves the opportunity while due diligence is completed. The seller, in return, is paid option consideration and may be relieved from actively marketing the site during the option period. Because an unexpired option represents a lingering right in the property, earlier options that were granted and not properly released can become a cloud on title. A prudent listing agent and title company will investigate whether any unreleased options or memoranda of option exist in the chain of title before closing a new sale. Elements of an option contract. An option to buy is still a contract, so the 5 essential elements you studied earlier must be present: offer, acceptance, consideration, capacity, and lawful purpose. But options also have additional requirements that distinguish them from ordinary letters of intent or vague promises to negotiate. To be valid and enforceable, a real estate option contract should be in writing. Because the contract involves a potential transfer of an interest in real property, statutes of fraud in most states require that options be in writing to be enforceable. Verbal promises to grant an option are not enough. Identify the specific property. The option must clearly describe the property using a legal description adequate to identify the lot and block, subdivision, city, and state, or another legally sufficient description. State a clear and definite option period. The agreement must specify an expiration date or a clearly defined timeframe for exercising the option. The option should state exactly when it begins and ends, and may even specify the exact time of day the option expires. State a definite purchase price and basic terms. The final purchase price and core terms of sale must be set or made determinable by a clear method. A court will not enforce an option that leaves major terms to be agreed later. An option is not simply an agreement to negotiate in the future. It must already contain the essential economic terms of the future sale. Provide actual, separate consideration. The optionee must pay the option a specific consideration that is separate from the future purchase price. This is often called option money or option fee and is usually non-refundable if the option is not exercised. In some lease options, portions of the rent may be identified in the option as consideration, but the parties must be clear about which portion is option consideration and how it will be treated. Meet all general contract validity requirements. The option, or must have capacity, must voluntarily agree and must sign the contract. It is not strictly necessary for the optionee to sign, because the optionee is not promising to perform. Instead, the optionee is purchasing a right. However, in practice, both parties usually sign to avoid disputes about whether a binding agreement exists. An option should never be confused with a letter of intent. A letter of intent simply summarizes key understandings between two parties and is usually non-binding. It can be a useful negotiation tool, but it does not give the buyer enforceable rights. An option, by contrast, is a binding contract that obligates the seller and can be specifically enforced if properly drafted. Option consideration and risk for the buyer. Option contracts highlight the concept of consideration in a very visible way. The optionee is not merely expressing interest. The optionee is paying for the right to purchase in the future. That payment can be small or large, depending on the value of the property and the length of the option period, but it must be real and must be at risk if the buyer chooses not to proceed. If the buyer is unable to complete the conditions in the option period, such as securing financing or selling another asset, the option typically expires and the option money is lost. For that reason, a licensee should make sure buyers understand that option fees are not just placeholders. They can easily recover. They are the price paid for flexibility and control. At the same time, an option can protect a buyer in a rising market. If property values increase during the option period, the buyer still has the right to purchase at the original, lower price. This can create significant upside and is one reason investors sometimes pay for options even when they are not yet ready to close. Common provisions in option contracts. Beyond the core elements, well-drafted options usually include several practical provisions that clarify how the option may be exercised, how the property is to be maintained, and how the option money will be handled. A notice of election clause explains exactly how the optionee must exercise the option. It may state that the optionee must deliver written notice of election to the option or by a certain date and time, often in a specific form and by a specific method. This might include delivery by personal service, certified mail, or electronic transmission to a designated address. If failure to follow the method of notice could result in losing the option, the instructions must be crystal clear. Forfeiture terms explain what happens to the option consideration if the option is not exercised. Typically, the agreement states that if the option period expires without exercise, the option, or is entitled to keep the option fee as liquidated damages for having removed the property from the market during the option period. Property and title condition warranties may appear in the option to protect the optionee's expectations. The option or may promise to maintain the property in substantially the same condition during the option period and to convey marketable title, free of undisclosed liens, at closing if the option is exercised. A crediting provision states how the option fee will be applied if the option is exercised. The parties may agree, for example, that the entire option fee will be credited toward the purchase price, applied to closing costs, or applied to the earnest money deposit. In lease options, the contract may also state how much of the monthly rent will be credited toward the purchase price and under what conditions. Assignment terms address whether the optionee may assign the option to another party. Unless the option expressly prohibits assignment, options are generally assignable. Investors sometimes use this to profit by selling the option itself to a third party, rather than purchasing and then reselling the property. If a seller wishes to avoid assignments, the option should clearly state that it is personal to the optionee and not assignable without written consent. Legal aspects, equitable interest, recording, and enforcement. When an option is signed and consideration is paid, the optionee acquires an equitable interest in the property. That means the optionee has the right, but not the obligation, to obtain legal title by exercising the option. This equitable right does not by itself convey ownership or create a full property interest like a deed would, but it is still a significant contract right. Because this equitable interest can affect marketability of title, options are often recorded in the public records, either in full or by a shorter memorandum of option. Recording puts the world on notice that someone holds an option. Any subsequent purchaser or lender who examines title will see the recorded option and understand that the optionee may have rights that must be dealt with before title can be freely transferred. Courts will enforce clearly drafted option contracts, including orders for specific performance when the optionee properly exercises the option within the option period. However, they will not enforce vague or incomplete options that lack essential terms. An option that simply says the buyer can purchase at a price to be determined later, or that critical terms such as price, method of determining price, closing date, payment terms, and method of conveyance will be negotiated in the future is really just an agreement to agree. Courts typically refuse to rewrite such agreements by supplying missing terms and instead declare them unenforceable. For this reason, when a licensee encounters an option clause in a lease or other document, it is important to check whether it clearly states or clearly defines the future purchase price, the timing of closing, the method of determining value if an appraisal is used, how disputes about appraisers will be resolved, who will handle escrow, and what conditions must be satisfied. If these items are left vague, the parties may not have an enforceable option at all. Options versus rights of first refusal. Options are often confused with rights of first refusal, but they operate differently. An option gives the optionee the exclusive right to purchase at agreed terms, whether or not the seller has received any other offers. The optionee can choose to exercise that right at any time within the option period, and the seller must sell at the agreed price. A right of first refusal, by contrast, gives the holder the first opportunity to buy the property if and when the owner decides to sell and receives an acceptable offer from a third party. The seller can market the property freely, and only when an outside offer is received must the seller give the right holder a chance to match or accept that offer. If the right holder declines, the seller is then free to proceed with the other buyer. Rights of first refusal often appear in leases where a tenant wants first dibs if the landlord ever chooses to sell. among family members who want to keep property within the family, in condominium or HOA governing documents, and in mobile home parks, where the park owner may wish to prevent homes from being removed from the park. These clauses typically require the seller to give written notice of any proposed sale terms and give the holder a specific time and method to respond. Both options and rights of first refusal must be drafted carefully. If the language is vague about timing, notice, pricing, or conditions, the clause may be difficult or impossible to enforce, and disputes can quickly become expensive. Practical risks and best practices. For buyers, the main risk in an option is losing the option fee and any rent credits if they do not or cannot complete the purchase. They should be realistic about their ability to secure financing, sell existing property, or complete due diligence in the option period. For sellers, the risk lies in being locked into specific terms while the market may be changing, and in having their property effectively off the market during the option term. They should be satisfied that the option fee and the length of the option period fairly compensate them for this restriction. From a licensee's standpoint, the best practice is to treat option language with the same seriousness as a full purchase contract. Use appropriate forms, avoid drafting new legal language, and encourage both parties to seek legal advice if the transaction is complex. Make sure dates, price, notice procedures, and crediting of option money are all written clearly. Review summary. In this section, you learn that an option to buy is a unilateral contract granting a buyer the right, but not the obligation, to purchase property at a set price within a defined time. You saw that the buyer, optionee, pays separate, non-refundable consideration for this right, and that the seller, optionor, is bound to sell if the option is exercised according to its terms. You examine the essential elements of an enforceable option contract: a written agreement, an accurate legal description, a specific option period, a definite purchase price and terms, separate consideration, and the usual requirements of capacity, voluntary agreement, and lawful purpose. You learned that options differ from letters of intent because they are legally binding and can be specifically enforced if properly drafted. You also explored common provisions that appear in options, including notice of election, forfeiture of consideration, property and title condition warranties, crediting of option money, and assignment rights. You saw that options create equitable interest in property and are often recorded to put others on notice. Finally, you compared options with rights of first refusal and recognized that vague or incomplete options may be treated by courts as unenforceable agreements to agree rather than true options. Discussion. Why is it important for an option contract to state a clear purchase price or a clear method of determining that price? Answer. Without a definite purchase price or a clear method for determining it, a court cannot reliably enforce the option. The agreement becomes an invitation to negotiate rather than a true option. Clear pricing allows the court to order specific performance and gives both parties predictable expectations. How does the role of consideration in an option contract differ from earnest money in a standard purchase contract? Answer. Option consideration is paid in exchange for the right to buy in the future and is usually non-refundable if the option is not exercised. Earnest money is part of the purchase consideration in an already binding bilateral contract and is generally refundable if contingencies fail. Option money compensates the seller for taking the property off the market. Earnest money primarily shows good faith and secures performance. Why might a tenant buyer choose a lease option instead of buying immediately? And what are the main risks? Answer. A tenant buyer might choose a lease option to allow time to improve credit, save a down payment, or test the neighborhood while locking in a purchase opportunity. The main risks are losing the option fee and any rent credits if they cannot or choose not to buy, and possibly overpaying if the agreed price turns out to be higher than the future market value. How does recording an option protect both the optionee and future purchasers or lenders? Answer: recording an option puts the world on notice that someone holds a right to purchase the property. This protects the optionee against later buyers who claim ignorance and helps title companies, purchasers, and lenders identify and address this outstanding right before closing, thereby preventing future disputes and clouds on title. Closing remarks. Option to buy contracts give buyers and investors a powerful tool to control property without immediate obligation and offer sellers a way to be compensated while granting that control. They sit at the intersection of traditional contract law and real estate conveyance and require careful attention to detail. As you move deeper into this chapter and into more advanced transaction structures, remember that every creative deal still rests on the same core principles: clear terms, real consideration, and enforceable promises. A licensee who understands how options work, where they can fail, and how they compare to rights of first refusal will be far better equipped to guide clients through complex negotiations and protect their interests.